Welcome everybody, thank you for joining us. I'm Maria Scotland from 5 St Andrews Hill. I'm the joint head of the family team at 5 St Andrews Hill. And today I'm joined by Rosalind Fitzgerald from Bindmans. Rosalind and I share the fact that we both practice in financial applications on the breakdown of marriage, and we have a shared concern during this pandemic about our clients, and in particular the financial arrangements which involve buying and selling properties in their divorce. Rosalind, do you want to introduce yourself to everybody and tell them?
Yeah, absolutely. So as Maria said, I'm Rosalind Fitzgerald and I am a family law specialist, and my particular specialism is in financial matters arising from the breakdown of family relationships. And as Maria said, we are both concerned, and our clients are concerned. Our clients are contacting us with concerns about their financial arrangements with the new world of the pandemic. One of the biggest issues we're seeing at the moment is with regards to orders for sale or agreements for selling of property. So we're going to start by just going through some of those issues and try and provide some guidance around selling properties in the time of the pandemic. Yeah. So Maria, I think you're going to start with, what does our client do when they are committed? An order has been made, an agreement has been made, probably after a lot of negotiation, possibly after court proceedings. They've got a binding court order to sell or to move out of their family home or other property by a certain date under a financial order. Yeah. Maria, could you talk a bit about that?
Yeah, absolutely. And it is a big concern. We both live down in the south. We practice in this area. For us, our clients coming to us, one of the main assets in a divorce is usually the property that they live in, they have lived in, or else the holiday homes that they've owned with their spouse. And we've spent the last 6 months, a year, could have been agreeing an order whereby they either are going to move out of a property on divorce or they're going to sell it. And of course, the stay-at-home rules have kicked in. Now, the government guidance about moving during this time is that the party should delay selling or moving if at all possible, but only move if the move is critical. But of course, one of the questions for our clients is, well, what does critical mean? Particularly if the other side is saying, you have to move, you owe me my share of property. So what is critical? Critical, there is no definition for it, but critical, I would say, is where one of the parties is vulnerable, has to move, or either they have to move for health reasons, or they have to move because they're moving into an old people's home, that sort of thing. That would be critical. But in all other circumstances, then the move isn't considered critical. And then the question becomes, what do they do?
That's right. I think the government has also given some additional guidance, but where people are contractually obliged to move, and one of the parties in the chain, for them it's a critical move, or you can't agree a delay, then that can still happen, but it shouldn't be happening, as you say, unless one of these critical factors is there. Obviously, if you're in a chain and you've got an unoccupied property or a new build property, that's going to lessen the risk. Yeah. Removal companies still working? The British Association of Removers has issued some guidance. They are saying their members only want to fulfil the most essential move transactions in line with the government guidance. They want a full risk assessment, understandably, and personal protective equipment. Great shortage of that, as we know in this country. But removers want that to be available for them, understandably. They're going out there doing their job, putting themselves at risk. But if that is available and you have to move, it can happen. Issues around delay, though. What happens if all the parties in the chain have agreed to delay? We're going to delay. One issue is that,
isn't it? Because you very often we're talking to a client, but it's not them moving on their own. They're usually part of a chain, and that's fine if they're chain free, and it's fine if they're moving it into unoccupied properties you highlighted before. That then means that they can move potentially if they can find a removal company, because of course, as you said, we've got the concerns about the removal company. But if you've got a chain, then everybody needs and requires each to move, so that each can move, which requires a lot of work, negotiation and working together, doesn't it? And of course,
Absolutely.
Sorry, I was going to stop you.
Sorry, I was going to add one of the issues around that is whether you've got a mortgage that's going to expire. That can often put a lot of pressure on a chain, and you might have parties who are willing in principle to delay, but their mortgage is going to expire. But there has been some guidance given from UK mortgage lenders, building societies. There has been a commitment to try to extend mortgage offers by 3 months from their current expiry date. So most mortgage offers expire in 6 months, another 3 months on top of that, and some flexibility as well from lenders. This is on a case-by-case basis, but if financial circumstances have changed, and there are now worries of affordability, lenders have they've made a broad commitment to try to be flexible and work with their applicants. How that works in practice is obviously going to be on a case-by-case basis. But I suppose really the next issue is then, if there has to be a delay, what happens if there's an order? You've got to move by such and such a date. What are the courts saying about that?
Yeah, and the purpose of an order is always to ensure that everybody knows exactly what's happening on what date, and that there is compliance. However, in these times, people can't comply with given dates that they agreed to before. And so the first thing to do, and that everybody is being urged to do, both by the government and certainly lawyers would encourage, is reach out to the other side and see if you can agree an extension of time, if you can agree to vary the terms of your order, particularly if you fixed a date for moving out of a property, or a date to sell a property and release capital and pay to the other side. That means in some circumstances where parties aren't able to communicate properly, then look to agree to mediate or to go to arbitration. That's always, if you can't speak directly to the other person because you've got a relationship that's poor, and that generally tends to be the case, doesn't it? Because that's why they've come to lawyers in the first place. But where you've got parties who really, there is no communication, there is no agreement, then the next stage would be, on my advice, would be make an application to the court to apply to extend the time. The court, there is a recourse to the court through making an application, what we call a D50K, sorry, a D11, which is the application to extend the time. The other party has open to them to make an application to enforce the terms of the order, which is the D50K. The two do go hand in hand. You may find if you apply to extend, the other party is going to seek to enforce. But the court's alive to these issues at the moment. And in fact, there is an indication from the courts that they would waive the fees for issuing those kinds of applications, because they're anticipating, expecting that people are in these circumstances. And so what you would do is you'd seek to apply to extend your time. The courts are operating at the moment, and they're doing so what we call remotely. So that means by telephone or by video. So your application is made online, it's received online, and the court then, once they've received it, allocate you some time in the ordinary way that they would if the courts were still operating to the public, allocate you a time before a judge when you will be dialed in by telephone, or there'll be as we are on Zoom or Skype, a hearing, and you then ask the judge to permit you an extension time. The likelihood is that you're going to get that extension, don't you think? And so then the next question, so that deals really with what do we do if we're committed to moving, we're committed to selling, or else we're committing to raising a mortgage and buying out the other side. sharing a property by a certain date. And we've covered all the grounds about, well, you can do, but it has to be safe. The reality is, isn't it, that most people are in a chain, most people have got mortgages, most people are unable to move at the moment. Looking to the future, what do we do when this lockdown is the stay-at-home rules are lifted? And the concerns already that we're hearing from our clients is those that haven't yet reached agreement. What will the housing market look like when all of this is over? And or what about when I do come to move, what about the price of my property? And what are we doing?
Absolutely. I mean, you know, the answer at the moment is we don't know. Nobody knows. Is there going to be a housing market? You know, am I going to be able to sell my property? Are prices going to go down? I think there's two schools of thought on this. There has been some commentary that there's going to be a boom because all of these people who want to move currently or have wanted to value their properties. Yeah, they've not been able to do so. They've not had people been able to come to see their houses, and that doesn't comply with the stay-at-home rules. You know, there's no exception for going to look at a house to see if you want to make an offer in it. So there's one school of thought which says that we're possibly going to have a boom. All these houses are going to come flooding back onto the market, and it's going to kickstart the property market again. Others are suggesting, you know, the opposite. Looks like, unfortunately, we're going into a recession. The extent, severity of that, we don't yet know, but that could well impact severely on house prices. And those people who are in the point of their divorce where they've been negotiating, you've been perhaps providing some financial disclosure, things have been going on for some time, those valuations which you had prior to the pandemic are all going to need to be redone. And really all we can advise at the moment is a wait and see approach. If things are a little bit further along, agreement for sale has been reached and that's not yet falling, or it's not hopefully not falling apart. You know, contracts can still be exchanged, mortgage valuations can still be done, searches, surveys, energy performance certificates. Some of these require inspections of the home, but the guidance is that these can happen with appropriate social distancing and you know, precautions being taken. The difficulty for some of our clients will be those who have entered into an agreement shortly before the pandemic, or a final order has been made. And if a final order has been made after contested hearing, this will be an order following lengthy negotiations, probably lengthy lawyers' fees, probably huge amounts of legal costs, and you know, an incredible emotional involvement getting to that point. If you have an order, a financial order of divorce which has been made shortly before the pandemic, and you are now watching this and seeing what's going on around the world and saying, well, this is unfair, my business is falling apart, you know, I don't know if it's going to survive. The shares that I hold of these investments are worth very little. I don't know what the value of the property is. So an order has been made on assumptions which now just may be completely incorrect. What do our clients do?
Yeah. Those where they've agreed, I'll take the house, for instance, and you take the business, or you can take the liquid capital. Big concern for them, wouldn't it? So
absolutely. So lawyers are talking a lot about whether the current pandemic constitutes something that we call a barter event. What is a barter event? It's an event where something exceptionally unexpected has happened, which undermines the basis on which a final order was made. It's extremely rare. We were talking, Maria, before we started recording, and I think you said in 25 years of practice, you've never had a barter event. Yeah. I've got 18 years of practice.
Succeeded.
Never had one. So this may be the time, we don't know, we're going to discuss it.
floodgates argument, isn't it? The courts have never wanted to set aside consent orders or final orders. The reality, for any reason, if they do it for client X, it sets a precedent, doesn't it? Oh, I didn't know that I was going to be made redundant. And therefore, that then sets a precedent, and the courts don't like that because it's what's called a floodgate, sets a precedent for anybody after their order who's made redundant or whatever it may be, can set aside their order. So it's very tight, and it's, like you said, 25 years, I've never done one. I believe you have though, haven't you?
I've had one. So I've got 18 years of practice in family law, and I had one barred event, which was a very sad situation. Very shortly after final order, the husband, who was my client, received a diagnosis of a terminal illness. They actually he had a substantial settlement, and it just, unfortunately, it was something that would not have happened had we known of the terminal diagnosis at the time. And there's
one of those cases where they say confined on their facts. There aren't going to be floodgates of people who get those sorts of diagnoses immediately after their orders, are they? Which is very similar to Barder itself. That was also a very sad case and quite unusual, wasn't it? So
that's right.
The question is, and you were leading into this pandemic is really unique. I mean, the words that you hear all time and time again is unprecedented. And it's whether or not these unprecedented times would be Barder event. What's your view?
It's so difficult. There's we had a similar position, didn't we, after the 2008 financial crisis.
And we had test cases then, we had a test case, which was the test case.
So case of Meyerson, after the 2008 financial crisis. In that case, the wife had retained or was due to receive significant lump sums of cash and property assets, and the husband's settlement was mainly in investments, and the value of his investments dropped by something like 90%, and we're talking investments that were worth millions. This was a fairly big money case, and quite understandably he came back to court and said, I can't pay this lump sum anymore, my investments have dropped off the cliff. The 2008 financial crisis was, he argued it was something called, it was the Barder event, it was unforeseen, new events had occurred within a relatively short time of the order being made, undermined the basis of the original order, and the court said no. And I think you're right, Maria, that very much concerned about the floodgates argument. If the variation is found on this basis,
the same for everybody else. But you touched upon, there are factors which you've got to have present in your case, as well as the economic. Got to have been made very soon or very close time period prior to the event. So we're looking at orders that have been agreed or made very soon before the stay-at-home rules and the pandemic. We're talking about the beginning of this year. We're also talking about orders where, or you've then got to apply very soon afterwards, haven't you? So we're looking to try and make applications very soon, but it's whether or not this pandemic was unforeseen and unforeseeable, isn't it? And that is something which, the waters are yet to be tested, don't you think?
I think somebody will test for waters, and I think if you're that person thinking, can I test for waters, your first step is not court. This is the type of case where we as lawyers would say, that's a really interesting argument, and you as a client never want your lawyer to say that is an interesting argument, because that means we really don't know what the result is going to be, and it's going to create a lot of work and money in your lawyer's pocket, and not necessarily anything back in your pocket. The starting point is, as always, trying to negotiate, trying to discuss. We appreciate there are times where that is very, very difficult to do after what can be really acrimonious litigation, but it is always worth it, particularly in a case like this where your application is effectively going to be an attempt to make new case law. It is unprecedented. We have not had a pandemic. We've not had possibly this is going to be a recession of a lifetime. Nobody knows how the courts are going to treat applications. So if there is any scope at all for negotiation, your lawyer will talk to you about that. We will talk to you about that and say, you've got to try to agree it. But ultimately, it's a balancing of the expense, the risk, the uncertainty of litigation to what you think you're likely to lose or gain. But it's risky and difficult litigation. Yeah. Same goes for doing a deal now. In the midst of a pandemic, there is a lot of uncertainty, but I think it is still possible. There are negotiations possible, and I think
I think people are taking those cases that I am working on now. We're taking the view, if property prices, if share prices, if capital values are dropping, then that's going to have a knock-on effect. So whilst you may have a reduction in the a fall in the value of your home, the property you're going to be buying is going to be dropping in value. But there's only those cases where there's some liquidity and there's some reason for wanting to deal with the matter now, usually because it's been dragging on for a long time. And these cases not only have a financial drain on our clients, it's emotional as well, isn't it? For a lot of people, just
absolutely
with it. And that's always our take-home message, isn't it? Is to do things as quickly, as cheaply, financially and emotionally. So it's emotionally less painful for our clients, and that means sometimes just having certainty.
I always talk about that. What's the benefit of having a deal? It's not just for financial cost, it's the emotional cost. It's just having that certainty and finality. How much is that worth to you? And it's an unquantifiable amount, but it's often very important, particularly for people who this has been going on for some time, and that's the sort of factor that we can't put our finger on, but it's individual to everybody.
So I think the take-home message from this is don't panic. Don't panic, and negotiate. Communication, that's really difficult for parties going through divorce or breakdown of relationships very often, but it's not so difficult for the lawyer. Our role is to say, right, we're going to take the burden of negotiations off you, stand behind me, or I'll walk next to you and I'll walk you through this. And let's see what we can do by negotiating with the other side. And we're both very capable of doing that. And we've got lots of experience, haven't we?
Yeah, absolutely. And that's where the benefit is of having your lawyer negotiate. We don't have the emotion behind it, and we'll help you find a path through it. There is always, we have, I'm sure, both settled some really difficult cases in the past. There is always a route for settlement if parties are willing to do so. There's always some compromise that can be made.
Absolutely agree. Well, thank you, Ros. You have been Rosalind Fitzgerald. I have been Maria Scotland. It's been lovely. And we shall see each other again, no doubt. Thank you.
Yeah, hopefully not on the other side of a FADA appeal.
Take care.